Good morning. My name is Jocelyn Katz. I'm a director in the Competition Department of ENS Africa. I'm based in our Johannesburg office, but we also have offices in Cape Town, Stellenbosch, Durban, and various other places in South Africa, as well as various countries in Africa, including Burundi, Uganda, and Mauritius. I am a competition lawyer and specialize in all aspects of competition law, both in South Africa and various African jurisdictions. I'm here today to talk to you about COMESA. The structure of today's discussion is going to look at three things primarily. One, an overview of the COMESA legislation and how it operates. Two, we're going to focus on mergers in particular and their impact on multi-jurisdictional transactions. And thirdly, we're going to look at lessons learned and our experience of COMESA over the past year. To start with, we're going to look at some history. As you may know, COMESA stands for the Common Market for Eastern and Southern Africa. COMESA has its genesis in the mid-1960s. By 1978, after various discussions, the Lusaka Declaration of Intent and Commitment to the Establishment of a Preferential Trade Area for Eastern and Southern Africa was signed. It took another almost 20 years until a treaty was established, and the COMESA Treaty was signed on the 5th of November 1993 in Kampala, Uganda, and was ratified a year later in Malawi, Lilongwe, which is the current seat of COMESA, on 8 December 1994. The mission of COMESA is to promote economic integration through trade and investment in Eastern and Southern Africa. On the 14th of January last year, that's 2013, COMESA merger control regime became operative. The COMESA member states are Burundi, the Democratic Republic of Congo, Egypt, Ethiopia, Libya, Malawi, Rwanda, Sudan, Uganda, Zimbabwe, Comoros, Djibouti, Eritrea, Kenya, Madagascar, Mauritius, Seychelles, Swaziland, and Zambia. The main legislative documents comprising the COMESA legislative framework are the COMESA Treaty, the COMESA Competition Regulations, COMESA Competition Rules, COMESA Rules, and the COMESA Rules on the determination of merger notification process and revenue sharing of merger filing fees. The structure of COMESA is as follows. We have the Commission, whose role it is to monitor and investigate anti-competitive conduct within the common market and impose penalties for anti-competitive conduct, and they cooperate with national authorities of member states. The current director is George Lepemile. His role is to administer the affairs of the Commission. The obligation is that the director of the Commission must be a citizen of a member state. After the Commission, there is the Board of Commissioners. They are the supreme policy body of the Commission, consist of 9 to 13 commissioners appointed by the Council, and they issue final determinations and adjudicate various competition matters and hear appeals. Following the Board of Commissioners is the Council of Ministers. Their role is to monitor and keep under constant review the proper functioning and development of the common market. They make recommendations to the authority on matters of policy, and they make regulations, issue directives, and take decisions in respect of the common market. The authority is the supreme policy body of the common market and consists of heads of states or government of member states. Following that is the Court of Justice, comprising 7 judges appointed by the authority, and they have jurisdiction to adjudicate upon all matters referred to it pursuant to treaty failure or contravention by member state. Counsel can be referred to court by another member state, resident of member state, or Secretary General. I'm now going to turn to look at the legislative framework and how it operates. We start by looking at Article 3 of the regulations, which sets out essentially the jurisdiction and application of the Act. Article 3.1 provides that the COMESA Treaty applies to all economic activities, whether conducted by private or public persons within or having an effect within the common market. And 2, it applies to conduct which has an appreciable effect on trade between member states and which restricts competition in the common market. We now turn to the specifics of merger control and a merger as defined. Article 23.1 of the regulations defines a merger as the direct or indirect acquisition or establishment of a controlling interest by one or more persons in the whole or part of the business of a competitor, supplier, customer, or other person. This very closely reflects the South African Act, which is structured in much the same way. And as we will go through the other provisions of the regulations, I will point out to you the similarities between the South African Act and the COMESA Act, which obviously assists us in interpretation of statute. The following article, Article 23.2, serves to define further what a controlling interest is and provides that any interest which enables the holder thereof to exercise directly or indirectly any control whatsoever over the activities or assets of the undertaking. Now, clearly, this is a very broad definition. While the South African Act does refine it or define it more clearly, this is clearly intended to cast the net particularly wide. It also clearly includes various minority protections which would bring an acquiring party or a purchaser under the ambit of control for purposes of COMESA. Draft merger guidelines provide further insight into what constitutes control, and this mirrors very closely the South African position. It provides as follows: control shall be construed by rights, contracts, or any other means which, either separately or in combination, and having regard to the considerations of fact or law involved, confer the possibility of exercising decisive influence on an undertaking. The Commission shall infer control if the person or undertaking beneficially owns more than one half of the issued share capital of the undertaking, is entitled to cast a majority of the votes that may be cast at a general meeting of the undertaking, or has the ability to control the voting of a majority of those votes that may be cast at a general meeting of the undertaking, or has the ability to control the voting of a majority of those votes either directly or through a controlled entity of the undertaking. Now, this reflects very closely the South African Act. 1, it refers to beneficial ownership of shares, and 2, voting of directors. The third one, which reflects identically the South African Act, is able to appoint or to veto the appointment of a majority of the directors of the firms involved. It then goes on to say control shall be a holding company and the undertaking, where the undertaking is a subsidiary of the holding company, and in the case of an undertaking being a trust, has the ability to control the majority of the votes of the trustees or to appoint or change the majority of the beneficiaries of the trust. In the case of an undertaking being a close corporation, if a person owns the majority of the members' interest or controls directly or has the right to control the majority of the members' votes in the close corporation, then it will be considered to be control. Finally, there is the catch-all provision, which is akin to our Section 12.2g, which says a person controls a firm if that person has the ability to materially influence the policy of a firm in a manner comparable to a person who in ordinary commercial practice can exercise an element of control referred to previously. While the concept of material influence has had an enormous amount of press in South Africa, and obviously we have developed a fair amount of jurisprudence over the last 14 years, it's not clear precisely how COMESA is going to interpret it. The draft merger assessment guidelines do provide the Commission's view on the term material influence as follows. They've indicated that it is their intention that material influence will be assessed on a case-by-case basis, that they will look particularly at an assessment of the acquiring firm's activities. They'll consider an acquiring firm's ability to influence policy relevant to behavior of the target firm in the marketplace, i.e. management of the business, in particular in relation to its competitive conduct. And therefore, it includes the strategic direction of a firm, as one would expect, as well as its ability to define and achieve its commercial objectives. We will consider an acquiring firm's ability to block special resolutions, taking into account things like share ownership, distribution and holders of the remaining shares, patterns of attendance and voting at recent shareholders' meetings, and any special voting or veto rights. So it appears that the analysis to be conducted will be somewhat similar to the analysis conducted by the South African authorities. In addition, the Commission will review the proportion of board of directors appointed by the acquiring firm, which seems to be more akin to a voting rights type analysis. In any event, it appears that they will be drawing from the learnings of both the South African authorities as well as authorities abroad. So we've now looked at the overriding jurisdictional test as well as the definition of a merger. In order for a merger to be notifiable, Article 23.3 of the regulations provides that both the acquiring firm and target firm, or either the acquiring firm or target firm, must operate in 2 or more member states, and the threshold of combined annual turnover or assets provided for a section below must be exceeded. Now, unfortunately, as you may be aware, the thresholds have currently been set at 0. So currently, the position is that to the extent that either the acquiring firm or the target firm has activities in 2 or more member states, then regardless of the level of turnover derived in either of those member states, the transaction will be notifiable. I'll come back in a moment to Article 23.3 and its apparent contradiction with the jurisdictional test laid out in Article 3. But for now, we'll just turn to the notification of a merger, and Article 24 provides that a party to a notifiable merger must notify the Commission in writing of the proposed merger as soon as it is practicable, but in any event no later than 30 days of the party's decision to merge. Now, clearly, this creates pre-implementation concerns because negotiations may continue 30 days post a decision to merge, and if no notification is made, then there is a breach. The Commission has indicated to us that the interpretation is 30 business days based on the Malawian calendar. In addition, decision to merge, in their view, occurs when there is established a concurrence of wills between the merging parties in the pursuit of a merger objective. But of course, this is fairly ambiguous because a decision to merge may be taken without it being recorded in an agreement. We have to date interpreted it as the signing of the merger agreement. Clearly, where either the target firm or the acquiring firm has activities in 2 or more member states, notification will be required regardless of the level of turnover derived by either of the firms. Now, notification must be accompanied by the requisite filing fee, and as you may have heard, filing fees are fairly high. The fee is to be calculated at 0.5% of turnover or 500,000 COMESA dollars, whichever is lower, of the combined annual turnover or combined value of assets in the common market, whichever is higher. Now, this is a fairly poorly drafted section, which is ambiguous. For clarity, 1 COMESA dollar is equal to 1 US dollar. So we are talking about a maximum filing fee of $500,000, which is fairly exorbitant. It appears to us that the proper interpretation of the section is that the filing fee is the lower of 0.5% of the combined turnover or combined assets in the common market, whichever is higher, or $500,000. This interpretation has been confirmed by the Commission in its document entitled Interpretive Meaning of the Notification pursuant to Rule 55.4 of the amended COMESA competition rules. 24 deals with penalties for failure to notify. 24.2 provides that any notifiable merger carried out in contravention of the treaty shall have no legal effect, and no rights or obligations imposed on the participating parties by any agreement shall be legally enforceable in the common market. In addition, 24.4 provides that a penalty imposed may not exceed 10% of either or both of the merging parties' annual turnover in the common market as reflected in the accounts of the preceding year. It is, so far, at least to us, unclear how the Commission is practically going to go about enforcing non-compliance with the regulations, but in any event, that is the position as it currently stands. 25 of the regulation sets out the time periods. The investigation commences from the date that a complete notification is received, and the Commission must make a decision within 120 business days from receipt. The Commission may extend the 120 business day period with consent from the Board, but it does not indicate the maximum period of the extension, which is somewhat problematic. Business days is also based on the Malawian calendar. George Lipimile, the current director, has, however, indicated that the Commission doesn't intend to take the full 120-day period, and that they are in fact working on a fast-track procedure, in terms of which fast-track mergers, which are not yet defined, but one would assume that these are fairly simple mergers, will take approximately 4 to 6 weeks from date of notification, and that the more complicated mergers will seem to take around 90 days. But of course, they do have the statutory ability to go all the way to 120 business days, which, as mentioned before, may be extended. That broadly sets out the procedures to be followed when dealing with a merger. I would like to deal with some interpretative issues and difficulties that we have faced, and then I'm going to turn to some early learning that we've experienced over the past year. Now, the relationship, as you may have picked up, between Article 3 and Article 23.3 has created much uncertainty. In our view, Article 3.2 of the regulations sets out the overriding requirement that must be satisfied before the regulations as a whole, including the merger control provisions, find application. The Commission has indicated that it does not agree with this interpretation, but instead has indicated that where the requirements of Article 23 are met, i.e. where the regional dimension test and the mandatory thresholds are met, then the merging parties must notify the Commission, and the Commission will assess whether the conduct has an appreciable effect in the common market. We do believe that there may be some sound legal backing in questioning the Commission's view in this regard, and taking it on directly if the merging parties have the appetite to do so, but the discretion will obviously lie with the merging parties. The position as it currently stands is that the Commission does not allow for any manner of self-assessment on behalf of merging parties, and that they are not entitled to conduct an assessment as to whether or not there's an appreciable effect as a result of the merger. The implication for multi-jurisdictional filings, therefore, is that if the regional dimension test is met and the mandatory threshold test is met, i.e. 0, then parties must notify. This is fairly problematic given the high filing fees involved, but nevertheless that is the position as the Commission currently sees it. Regulations first came into force, it was unclear as to whether or not notifying COMESA would obviate the need to notify in other member states. There have been some toing and froing in this regard, with the Kenyan authorities insisting that they be notified regardless of whether COMESA was notified. But the position now seems to be fairly settled, and the position is this. To the extent that there is a regional dimension and COMESA is required to be notified, merging parties can notify COMESA and do not need to notify any of the other individual member states as well. Obviously, to the extent that there are African jurisdictions that do not form part of COMESA, that are not COMESA member states, then those jurisdictions will need to be notified independently. So in terms of early learning, we have filed various notifications with COMESA, and we have found the Commission to be fairly flexible and willing to rather facilitate business rather than frustrate it. The Commission's flexibility is in things like willingness to backdate notifications to reflect the date of electronic filing rather than waiting for original hard copy documents to arrive. Things like original filing documents versus accepting certified copies of documents. Things like not requiring an affidavit where documents don't exist. A simple statement that the documents do not exist is sufficient. In terms of logistics, one is required to submit hard copies of a filing, although, as indicated, the Commission has been fairly flexible in terms of the dates involved. Nonetheless, you are required to submit the original and 3 copies of the original to form part of the filing. So practically, we allow 3 to 5 days courier time from South Africa. We also indicate to clients that they should make payment of the filing fee in advance to facilitate the submission of the payment to the COMESA Commission. Indicated throughout the discussion, the COMESA structure of the Act, as well as the substantive assessment, strongly mirrors that of the South African Act. We have therefore approached the COMESA filings on the same basis that we would approach the South African filings. We've answered the questions in the same way, and we've conducted the same kind of analysis. In relation to the substantive test, we've applied the same principles that we would apply here. What is important to note in terms of the COMESA filing documents is that some of the questions have regional application, others have national application, i.e. applicable to a member state. What we have found during the investigative process at COMESA is that they will send questions, information requests in the ordinary course, similar to that of the South African authorities. The average time period has been approximately 3 months. The quickest approval that we know of has been 1 month. We suspect that the time period is likely to increase if the number of merger notifications increases, given the Commission's limited resources at this point in time. In addition, what we do know is that they are only currently considering mergers. They've not yet begun to exercise their other powers in terms of prohibited practices and other conduct under the Act. So in a sense, that's watch this space. So we think the COMESA Commission is likely to be a fairly active authority, and we look forward to further development over the next coming months and years. Thank you very much for your time. Bye-bye.